Okay, so I'll probably repeat myself a couple of times just as we've got people joining. Hello, if we've got anybody so far, we'll just give it another 30 seconds for people to join and then we'll get started. But welcome everyone. For those just joining, we're not completely silent. We're just giving it another 10 seconds and then we'll get started. We'll give a few more people a chance just to join us. Okay, it's 11:32, so I think we'll get started. Welcome, everybody. Thank you so much for joining us today. Today, we're going to be diving into the latest developments in the Employment Rights Bill and the Finance Bill, with a focus on what these changes mean for your organisation, supply chains, and then also what they mean for compliance. I'm Jordanna Green. I'm Director of Transformation here at Retinue, and I've specialised in technology and workforce design across frontline sectors for the last 15 years of my career. I'm going to be your host today, and I'm joined by Alison, or Ali Coates-Howard, and Nicky Green, who bring deep expertise in legal and practical risk management. Ali is our Group General Counsel for nGAGE Group, which includes Retinue as a business. And Nicky is a partner in the Employment and Pensions Division of Capsticks and leads their independent sector, working with private healthcare providers on a range of employment law topics. So we've really got the experts with us today. We've got absolutely tons to cover, lots of content. We will leave 15 minutes at the end of the session just for questions, but feel free to pop your questions in the chat throughout this webinar. One of our colleagues who's sitting behind the scenes will collate them just in case we don't get to answering everything, and we'll make sure that we do come back to you and get those answered after the session. So why we're here today, in our last seminar, we explored the Employment Rights Bill. And many businesses we speak with recognise the complexity and the effort involved with the ERB. And just in just a minute's time, Nicky's going to share insights and recent advancements on the ERB. But from what we're hearing, most organisations are well on top of the Employment Rights Bill. After the last webinar, many stakeholders told us they didn't even know the Finance Bill existed. And actually what we've been doing since then is working with organisations, helping them to understand and uncover hidden umbrella companies in their supply chains. And what we at Retinue are experts at is advising on strategies to transfer that risk. But first and foremost, what we're here for today, to be aware of the risk and potential risk. And I'll bring a particular client of Retinue's to light on that in a little bit later in this session. So let's get started. Nicky, if I start with you, can you kick us off by walking us through the key changes in the Employment Rights Bill since our last seminar?
Thank you. Yeah, I'd love to be able to do that. I'd love to have lots of news for you all today. We made the point last time that lots of the Employment Rights Bill was going to be subject to change and regulation. And I mentioned something called ping pong, which is where legislation flips between the House of Commons and the House of Lords while they debate what should go in there. And unfortunately, we're still stuck in ping pong. Some changes were made by the House of Commons, some changes were made for the House of Lords. They went back to the House of Commons, who rejected the changes by the Lords. It's gone back to the Lords. And the Lords are sticking to their guns on this one and saying that in terms of the bits that I think are most important for those who are joining today, with guaranteed hours, they want the House of Lords wants there to be an opt-out, which businesses think is really important. We talked a little bit about that on the last webinar, and saying that casual workers, 0 hours workers, can be a really, really helpful workforce supply for organisations, and lots of bank workers and 0 hours workers like working in that way. The guaranteed hours provision is obviously the concept that after a reference period, you will offer guaranteed hours contracts to those individuals. And that's an administrative problem, but also a long-term finance problem for some organisations who rely heavily on 0 hours workers. So the House of Commons is really keen on that. It's a key part of the manifesto, or was a key part of the manifesto for Labour. So they're very keen on having that in there. The House of Lords are saying, we don't think it works particularly. We want there to be an opt-out. So they've put that back in, that opt-out, and it's going back to the House of Commons again. They also want there to be a seasonal work exception inserted into the ERB for 0 hours and guaranteed hours bank worker contracts. That's gone back to the House of Commons. We're going to have to wait and see what happens to that. The problem with ping pong is that there is no end date in sight necessarily. And what it will mean is it could and is most likely to have an impact on the implementation of this legislation. We'll get into Christmas recess for Parliament. If we can't get an answer from the House of Commons before they go into recess, the likelihood is they'll have an impact on implementation dates. When we talk about the ERB, lawyers get very excited about it, particularly employment lawyers. It is really, really I say exciting, but also challenging. But the thing to remember is none of it is happening overnight. We've got kind of a long-term time frame, things happening in 2026, things happening in 2027. So you've got time to prepare for it. And this ping pong period will actually elongate that time frame probably. So that's a bit about guaranteed hours and what we're seeing, the debate that we're seeing playing out between the House of Commons and the House of Lords. Unfair dismissal, and what we touched upon last time, was that really interesting point about day one rights. We're used to a 2-year qualifying period. There are some exceptions, automatic unfair, where you don't need to have qualifying period of continuous employment. The government are really committed to day one rights, but had included this concept of a probationary period in the ERB. The House of Lords don't like that very much. They want there to be a qualifying period, and they'd inserted a 6-month qualifying period into the ERB. That's gone back to the House of Commons. There's loads of commentary on this, and I think a lot of people feel that that 6-month qualifying period is actually quite a sensible compromise. Whether the House of Commons feel and the government feel they are able to concede on that is another matter. But actually, and I think my view as well, is that that 6-month qualifying period is a good concession to make to get this across the line, because otherwise we're going to be stuck in this ping pong for quite a while, I think. So that's the update. Sorry, I can't give you more helpful news on that, but we're just stuck where we are for the moment. So keep your eye out basically for changes that are made there. What I did want to bring to your attention are the consultations that are out at the moment about some other aspects of the ERB and where we'll see changes. You'll probably know that the ERB is almost this kind of framework, and it's reliant on other pieces of regulation and statutory implements to add detail to it. So, and the government is really committed to the consultation process. It's incredibly important to get legislation right, secondary legislation right. There are consultations that are out at the moment, some of which I don't think are going to be so relevant to you, but you can let me know if I'm wrong on that. So trade union issues, really, really important for public sector organisations, but potentially not for you so much, but do have a look at them if you do deal with unions a lot. But the ones I wanted to touch upon about leave for bereavement, including pregnancy loss, and enhanced dismissal protections for pregnant women. Though both of those consultations are open until the 15th of January. They make really interesting reading. I don't just say that as a nerdy lawyer. I do think they make for interesting reading, and I'd recommend you have a look through, and if you've got comments, send them in to the government, because if you don't say anything, then your points can never be taken into consideration. Leave for bereavement at the moment is limited. There is a statutory right to paid leave, but it's limited to loss of a child. So that's someone under the age of 18. What leave for bereavement, the suggestion is that it should be an unpaid period of 1 week in the 56 weeks that follows the death of a loved one. So it's not limited to children. It's going to be much broader than that. The government is kind of recognising that's an incredibly difficult period when you lose a loved one, and they want to be able to give employees more rights associated with that. They do recognise that lots of employers are compassionate, but they want there to be a statutory right, and it's to unpaid leave, not to paid leave. But the questions range on seeking your views on who should be a loved one. What's the definition? Should it just be very close family members, children, mothers, fathers? Should it include grandparents? Should it be aunts and uncles and cousins? They're really seeking your views on what that bereavement leave policy should look like. The second one, on enhanced dismissal protections for pregnant women, you will hopefully be familiar with the fact that there is protection available for the moment for pregnant women against dismissal. We look at discrimination rights under the Equality Act. You will also hopefully be aware that redundancy protection was increased for women on maternity leave, those who come back, also people on parental leave fairly recently. But they really want an overhaul of the law around dismissal in relation to pregnancy. They're looking at the 5 fair reasons for unfair dismissal, whether we should exclude those completely when we're talking about dismissing a pregnant worker. They're looking at whether you should be able to performance manage a pregnant worker or someone who comes back from maternity leave, and that is for a period of 18 months. They're looking at conduct. Should you only be able to dismiss a pregnant or someone who's returning from mat leave for gross misconduct rather than misconduct generally? So this is a massive, massive change for me. So I definitely encourage you to have a read of that. The final point I wanted to make is not so much about the ERB, but it's a change that's coming in that it seems to be going under the radar slightly, which is a bit of a concern. It's a change to the ACAS early conciliation period. Hopefully you'll be aware that when an individual wants to bring an employment tribunal claim, before they can do that, they have to go through ACAS and the early conciliation period. And that has a knock-on effect on their time limitation period, so when they can bring a claim. That period is going to be extended to 12 weeks from the 1st of December. So it's coming in the next week, in fact. I don't think that's actually going to have a massive impact on the settlement of claims, because I think, Ali and I were talking about this, you tend to get a feel quite early on for whether a claim is going to settle, and changing the early conciliation period from 6 weeks to 12 weeks isn't necessarily, I don't think, going to lead to more settled claims. What it will do, however, is have an impact on the tribunal process and this backlog of claims that is building up and building up at the moment. If you have any employment tribunal claims, you'll know that they're not being listed for a very long time at the moment because resources are limited. So it's one of those points where I'd say just keep an eye out on that and be aware that that settlement process is going to be extended for another 6 weeks. That's my very quick wrap up of what's going on at the moment.
Thank you. So you started off by saying not much, and that ping pong is obviously fairly significant. Just a quick question before I move on to the poll. Is there one thing that everybody listening in relation to the Employment Rights Bill should get on top of in the next 12 weeks?
For me, it's those policies, it's those leave, the consultations that are going on at the moment. There's not an awful lot you can do. I think most people are getting on top of their 0 hours workers. I think you've done that after the last seminar. But for me, it's those policies. What do you say at the moment about pregnancy loss, about bereavement leave? Have a look at your existing policies and see what might need to change.
Great. Thanks so much, Nicky. So for anybody joining that hasn't watched our previous webinar on the Employment Rights Bill, just pop a thumbs up or a hands up or your name or something into the chat, and the team in the background will absolutely share that link with you. So before we dive into some of the detail around the finance bill, I'm just going to ask everybody that's listening to complete the poll. So this is the bit where we always go, fingers crossed, we've tested it lots of times, but hopefully everything works. In the bottom right hand of the screen, you'll either see the poll icon or you'll see the 3 dots that then take you to that. If everybody could just click through and let us know to what extent are your statutory directors aware of the risk from the finance bill. Everybody just can go in and start clicking, and hopefully I can start. Yeah, I can see some responses coming in. That's great. So full awareness at the minute is the lowest, so that's sitting at 15%. Limited and medium awareness. Oh no, medium is just taking over. So okay, that looks fairly static. So at the minute we're sort of middle of the road. I'm taking that as some do, some don't, but clearly nobody feels as though those statutory directors are experts in this area as it stands. So shifting into the finance bill and why this matters for all of you as organisation. Today, we're focusing on a specific element of the finance bill because it's really complicated and it's really quite considerable in size. But that specific element is umbrella legislation. There is a common misconception that the finance bill doesn't apply to organisations not using agency workers. And actually, in reality, we know risks can be hidden across your own staff if they've been engaged through an EOR or via an agency or a statement of work or labour-only contract arrangements. And that's one of the things that we'd really like to bring to light today. Here at Retinue, we've supported and continue to support lots of existing customers and customers that have reached out to us to help quantify those monetary risks across their supply chains. And what we found is those risks don't always sit where visibility is lowest. Sorry, we found that those risks often sit where visibility is lowest. So let me bring one of those to light for you. And this is a real case study of a construction and rail customer that we work with. So their organisation had £12 million worth of agency spend. They had 10 million in statement of work and 10 million in labour only contracts. And through the work we did with them, we identified that there was £2.7 million worth of potential exposure under the finance bill. There was a further 4 million, almost 4 million under the employment rights bill, and then 600,000 under the proposed right to work legislation. So I think everyone will agree they're not small numbers. And what it identified for that organisation in particular is not only the financial risk, but the need to do something about this right now. If anybody is interested today in understanding more about our exposure risk calculator, again, pop your hand, drop your name into the chat, and we'll absolutely reach out to you to help you do that kind of quantifying exercise. So those numbers, clearly quite scary. And what we want people to take away from today is if your organisation is bigger than the one I've just described, there is still risk. So let's start digging into the details. So what we'll hopefully bring to light for you today is where that risk sits, help you to identify how you can inform yourselves and manage that risk. And then importantly, where HMRC scrutiny is increasing, what that means for you and your organisation in terms of your legal position. So I'm going to lean on Ali here as our second expert to start exploring the finance bill and that umbrella change. So Ali, why do you think this part of the finance bill in relation to the umbrella legislation has flown under the radar for so many organisations?
So, I mean, we're all as diligent professionals in our market, whether that's procurement, HR, legal, sales, finance, we all keep an eye out, don't we, for legislation that might apply to us. And we do that through various sources. So, you know, it could be following experts like Nicky on LinkedIn. It could be trade updates. It could be press coverage. It could be through systems such as LexisNexis, Practical Law, that sort of thing. But you focus on what you think will apply to you, and then that generates an algorithm, and then you hear more about the same thing. And you don't know what you don't know. So if you're not looking out for this change, you're not going to know it's coming through. And what we found, and I did do a bit of research on this yesterday to make sure what I was saying was correct. What we're finding is any commentary on this change has been so focused on our industry, on the recruitment industry, and there's been less focus on the end client. So I think a lot of end clients are just missing it because it's not being talked about in that way. It's being talked about in our sector. So I think that's probably why it's going through. And maybe, you know, people don't have the Income Tax and Employment and Pensions Act as their top of their Google search on a daily basis, with alerts coming through. And so I think that's why.
Okay, so can you tell us then where this element of the finance bill came from and what's the government trying to achieve, Ali?
Yeah, so, well, what they're trying to achieve is a massive tax hole, basically. So, you know, lots of people think our market's unregulated. So I think I did when I came into recruitment. You know, we as an employment business, and Retinue as also falls under the definition of an employment business, which is the provider of temporary labour under the Employment Agencies Act 1973. We're regulated. We're subject to regulations, Employment Rights Act, Equality Act, same as all of you guys. But on top of that, we've got the Employment Agencies Act 1973, or what's left of it, which is very little. And then we've got what's called the Conduct of Employment Agencies and Employment Business Regulations 2003. And under those conduct regs, we're under the inspection of a government department called the Employment Agency Standard. So they inspect us, they come in, they look at, and they've got wide enforcement powers, including the ability to close a recruitment business down. Due to possibly the fact that the definition was created in 1973, umbrella companies are not caught by that definition and they're unregulated. So what the government is trying to do is bring them under the same regulation as us. So they will be considered a little bit like an employment business, caught by some of it, most of it, not all the same. But then on top of that, they have the tax loophole. So about 18 months ago, we fed into a consultation on tackling non-compliance in the market. And they were talking about figures of 500 million lost in disguised remuneration schemes in tax, almost all of which are through umbrella companies. Then on top of that, you've got losses through PAYE, national insurance, mini umbrella schemes, estimated about 400 million a year. So there is a hole in the budget of 900 million to £1 billion a year due to non-compliant umbrella schemes. So it's a huge number. So something had to be done. Then on top of that, around about 50, I think it's probably more, umbrellas go into liquidation every year. And they go under leaving tax. So even if they're not part of these schemes, they're still leaving unpaid tax and national insurance. And then you've got, I think I checked yesterday, over 100 umbrella companies listed on the HMRC tax avoidance. So basically what they're trying to do is protect the taxpayer, collect the taxes that are due, and regulate the umbrella market.
So tax is tax, obviously with yesterday's budget and today's conversation.
Absolutely. Yeah,
absolutely front and center. So Ali, if you could just break it down for us, what are the changes that we're seeing that the government are trying to implement?
Yeah, absolutely. So it's joint and several liability. For those of you who are know about IR35, it's a similar sort of change. It's passing the liability up from the initial taxpayer up through the supply chain, and it comes under the same piece of legislation. The finance bill will amend ITPA, which is where we find the off payroll legislation as well, and it makes us jointly and severally liable for the tax. So basically, if the umbrella company doesn't pay the tax, someone else in the supply chain will. And I think we've got some diagrams of the different models where I can show you where that liability will sit. But the key points are it's joint and several liability. And this is the really scary part. There is no statutory defence. There's no reasonable care defence to this. It's strict liability. So you can do all the due diligence you want in the world, and that will mitigate your risk, but it doesn't defend your risk. That HMRC can still raise a tax bill if the umbrella company is not paying. So what we're going to do in this bit, we've got 5 slides. I'll try and get them through them quite quickly, but we're going to look at where the liability sits in each supply chain. We're going to focus to begin with on those that sit in my world, in the recruitment world, and then we'll start looking a bit at how that could impact the end clients on the call. So this model is something I use when I'm training recruiters in our own business about our supply chain models. So this is what I call, I don't know if everyone agrees, the traditional employment business model. You know, client engages with a recruitment company, and that recruitment company goes out and finds them temporary labour, and they engage those workers in different ways. So they might engage them on a contract for services, which is what we call PAYE workers, or they might engage them through a PSC, a personal service company, which is your IR35 off payroll world, or through an umbrella company. So in that case, the contract between the umbrella company sits with the employment business. And in this model, under the new legislation, if that umbrella company doesn't pay the tax, and what's coming is secondary legislation to also include national insurance following the DUCAS case, which I'll touch on at the end, is that the liability will sit with the employment business. So in this model, you as end clients are protected, but if the umbrella company goes under or doesn't pay its taxes on time, then the employment business, the recruitment business, will pay for will pick up the liability. So in the next model, we're looking at the Retinue world, the managed service provider, the neutral vendor model. And this was a little bit of a surprise, I think. We knew that it was coming, that joint and several liability would sit with those employment businesses. But what's actually happened is, under the legislation, if you appoint a master service vendor, neutral vend, then the liability skips the employment business and goes to the neutral vendor. Now, the reason this was surprising was all of the second tier suppliers, those employment businesses, they're responsible for their own umbrella company engagement. And what you would typically find is that a Retinue of the world, a neutral vend, master vend, wouldn't necessarily see all of those umbrella companies and has no control over those umbrella companies. But in this model, the liability will jump to Retinue. And Retinue was an early adopter of a system that will allow you as Retinue to have much more visibility over that supply chain. But again, no statutory defence. That in itself is not a defence. So for a neutral vendor, master vendor, all liability could skip up to them. So then what we're going to do in the next model is we're going to start looking at where the liability may jump to the client. And in this case, what we're talking about is there is a piece of legislation, there is an element of the finance bill that talks about connected persons. And this is the bit that I think has been missed in a lot of commentary. So many employment businesses, and we'll see in a second, neutral vendors, will have in its group an umbrella company. We do. We've got one called Enhanced Payroll. And the reason we do that is because we have control of that. We know our taxes are remitted on time. We've got complete control. It's our umbrella company. We know what services are being delivered. And that happens across the board. There are a lot of recruitment businesses that operate like this. We're not unusual at all. In that case, though, the liability jumps the employment business and goes to the client. So in that case, the joint and several liability will skip up to the client. So, and you may not know in your supply chain, it's one of the things we're going to talk about at the end about what actions you can take. You might not know that your umbrella company and your employment business are related parties, that they're connected persons, because they don't have to tell you. They have to tell the workers. Every assignment schedule we send to a worker must say that we're connected to the umbrella company, but that doesn't flow up the other way to the client. So that's one of the elements where you might find risk in your own supply chain. And then if we move to the next slide, it's very similar position. So if your neutral vendor is connected, whether it's your employment business or your neutral vendor, the same thing could happen. And so one of the things I would say is what you want to start looking at, what you want the conversations you need to start having now ahead of April, because this is coming in. This is not delayed by the ERB. This comes in April. Is start talking to them and understanding what their supply chain looks like. Are they connected to any umbrella companies supplying into our clients? So that's one element of where it might sit with a client. But if we skip to the last model, this is the other part that I think there's just not enough conversation about. You might not know you're engaging an umbrella company directly. And if you're the contract holder, then you are liable. So in this model, it's you as client engaging with an umbrella company. And in that case, the liability shifts to you. So when might you be engaging with an umbrella company? Because you might think, well, I'm not. It could be that you have workers on visas and don't have the right to sponsor. So you're engaging through an employer of record. They would fall under this definition of umbrella company. It could be, we know that some clients set up statement of works with umbrella companies where they effectively have a master service with an umbrella company, and then the umbrella company takes responsibility for all the engagement underneath. And so they then manage that labour for you rather than having an employment business. In those models, the liability would again move up to the client. And I think it's this bit that is possibly not being discussed enough in commentary.
Thanks, Ali. Okay, so pause there for a minute because there's a huge amount of information. When you talk about joint and several liability, what are the actual or potential consequences of not knowing about these legislative changes? Sort of hit us with worst case scenario. What could happen for organisations, be that a small, large, medium-sized organisation?
It's a big old tax bill. It's a tax bill from now, but secondary legislation is coming in that will also cover employer national insurance. And I briefly mentioned the case before I move on to the case of DCAS. It could also be fines and penalties, even though you had no control over it. The legislation still allows HMRC to levy a fine and a penalty under this. So it's a tax bill, basically, an out of the blue tax bill for something that's largely not in your control. You can do due diligence, absolutely, and there's risk mitigation, and we've put huge risk mitigation into our, Jordanna, you'll know, we've had numerous meetings, group board calls, there's training ongoing internally about what we're doing, the accreditations we expect our umbrella companies to have, and how that will operate. But yeah, it's an out of the blue tax bill. Now, at the end of, I think it was December 2024, it was certainly at the end of 2024, there was an umbrella company called Ducas, which if you're in the health and social care sector, you may have heard of, because they're huge, or they were huge in that sector. And HMRC took the slightly unusual step of obtaining a freezing injunction against them. So they froze Ducas's assets, estimating that around 171 million had been unpaid in national insurance contributions. Now, it's a bit of an odd one, this one, because we've known, when I came into recruitment, people talked about dodgy umbrella companies. I do apologize if there are any umbrella companies on the call, because you're not all dodgy, but it's something that is just openly discussed in the market. And this particular umbrella company, everyone I spoke to had questions about them. I wrote to them and they sent me a counsel's opinion, but the counsel's opinion is only ever limited to what you ask counsel to give advice on. So it's very limited, and it didn't cover the full risk. And so the secondary legislation will look about how they tackle the sort of Ducas of the world. And if you do have them in your supply chain, so it's Ducas, and now they've launched an investigation into their sister company, MaxiPay, and also into their parent company, FPL Holdings.
Great. So make sure everybody's noting those down, and just having a look at whether they're in your supply chain. That probably feeds quite nicely onto my next question, which was going to be, how can organisations, how can everybody on this call proactively uncover hidden umbrella companies in their supply chains? What can people actually go away and start doing?
So I think the first thing is look at your own risk. So, your employment businesses will already be doing, or should already be doing, something about this. So first step, speak to your HR team. Do you engage any of your own substantive staff through an umbrella company? Is it because you don't sponsor workers? Is it, there could be very many reasons why. Do you have a statement of work in system where you're using these umbrella companies to fulfill the labour? You've sourced the labour, but you don't want to employ them directly, so that you've engaged them through an umbrella company. I would say that is step one. Step two would be to look at your supply chain. If you have a master vendor, neutral vendor, then hopefully you have no off-contract spend, and they will be able to tell you if there's any connected person in that supply chain, whether it's with an employment business or whether it's the neutral vendor itself. So I would start speaking to your neutral vendors, master vendors. If you don't have one of those in and you manage your own supply chain, or even if you do have one in but you have some off contract, start speaking to your employment businesses. Ask them, which umbrella companies do you use? What accreditations do they have? How do you monitor them? What due diligence do you do on them? We as a group have decided to go, for example, for a approved supplier list that's all SafeRec accredited. Now, that isn't a get out of jail free card, but that's what we've chosen to do to help reduce reduce the list of umbrellas we use, but also mitigate our risk. And so if you come to any one of our businesses, we'll be able to tell you exactly what we're doing, who's in the supply chain. And the big one is, do you have a connected umbrella company? And are you using that connected umbrella company under my contract? Because we only use ours in certain circumstances, for example. So it's all about asking the questions. And I'd start asking them now, because April, with everything else that's going on and the Christmas period, is just really not very far off at all.
No, it's not. And, you know, I'm always responsible for leading these legislative changes operationally at Retinue.
Mm.
And last year, when we had national minimum wage, which is quite a common occurrence on an annual basis, we also had employers' national insurance increases. And actually, like you say, Ali, once everybody's back after Christmas, April just turns up before you know it. So we've got these further changes in April next year, where we know that national minimum wage is going up as expected off the back of the budget. So I think your point is really valid. We've now got, give or take, 5 weeks till the end of the year. People need to do something this side of Christmas to try and stay on top of what's happening next year. So I think probably for some people on this call, they might be responsible. But if people aren't the responsible person in the organisation, how does everybody listening communicate the urgency of these risks to their senior stakeholders?
I mean, I would, pass on this webinar, but, as a summary, all of our businesses, I've been speaking to all of them. I've been speaking with clients directly. I'm happy to speak with clients, senior management team, and provide an overview. It wouldn't be as detailed as this one, but I can jump on a call. I think speak to your HR teams first, because they've probably got the best idea, or your hiring managers, they've probably got the best idea of what's going on. Speak to them, see what knowledge they have, share this knowledge with them, and start asking them to look at the supply chain. And then you've mentioned the calculator. The calculator is a really good way of then finding the risk and analysing the risk.
Yeah.
Because tax is expensive, and if you've got one worker out with one of these umbrella companies, that's a small risk. But if you've got 10, 15, 20, suddenly your unexpected tax bill, which you had no control over, is suddenly so much more. And I think that's why when I looked at the tax calculator, and as you know, we're running it in our own businesses, I think that's a really important step.
Great, thank you. And I think just to touch on what you mentioned earlier, for anybody who is already working with Retinue, we have account directors across our business who are hugely knowledgeable in this space. No question is ever a silly question, so do reach out if you want to start to understand A, how we're handling it for you, but B, if there's any off-contract spend. I think the important thing is that we start to get sight of that so we can reduce any risk across those unknown umbrellas. So I think probably just in the interest of time, Ali, couple of final questions. Are there any recent trends in HMRC scrutiny that people should be aware of?
Yeah. So at the same time that we're all tackling this new umbrella legislation, it's coming up to the anniversary or the end of the limitation period for the initial private IR35 assessments. And so we are hearing a lot of feedback about HMRC sending letters, taking action to try and protect their position on collection under so obviously public sector has been around for a long time, and HMRC are very comfortable with that, but they've started taking action under the private assessments, under those status determination statements. And we know clients are getting letters. I've been speaking with other people in our industry. There's lots of letters coming through from HMRC. HMRC are then saying that they will issue a claim. Please don't worry about that, because they will enter into what's called a standstill agreement with you while they're reviewing any liability. They're doing it, though, to protect their position under the limitation period. What I would say is, if you have an employment business, a Retinue in the supply chain, please don't just pay the tax yourselves. We've seen that happen. It's a small amount, so people think just get it off the desk. It's £400-500. Actually, as long as you've got robust systems in place, HMRC aren't entitled to those funds, and there is a whole process for demonstrating the contract, the status determinations statement, and having those conversations with HMRC. I think because some of the communications say we will take legal action, it's beginning to worry people. But just engage with us. All of our employment businesses are really good at this, and will help support in those steps. But yeah, definitely increased scrutiny around those original status determination decisions.
Great, thank you. And then I think the two key takeaways here are: speak to your HR leaders to understand if anybody's ahead of you or at the same point in terms of the finance bill and umbrella companies, and then start to understand your supply chain via your MSP provider or any other company you engage with, or that supply chain that you are directly connected to. Okay, huge amount of information to digest there. I'm more familiar with it than perhaps other people. And even for me, I'm learning stuff every time we do these sessions. Let's just pause for a minute or so. And I've just got a second poll I'd like everybody to complete. So who in the business do we think owns the challenge of mitigating risk from the finance bill? So whilst everybody's just popping their answers in the poll, I was at a conference a couple of weeks ago and it was really interesting because finance leaders were talking about taking more responsibility in business transformation. So actually that's the reason for putting finance director in here, and naturally there is a monetary element, but I'm keen to understand what the perception is around who owns this challenge of mitigating the risk. So if everybody can start submitting, I think I can start to see people's answers. Let's have a little look. I should have said, I don't think there is a right or wrong here. This is definitely a perception piece. Interestingly, what's looking like the majority is finance director. So a couple of people have said no established owner, which my assumption is that means that it's, you know, lots of people or everybody's responsibility. 15 people have gone with procurement director, 31 have said workforce director, and then 46, so just marginally more at finance director. So that seems to be a majority from this group, certainly. So Ali's talked about the DUCAS case study. Nicky, I'm just going to pass back to you now just to bring another case study to life. So anybody here who is either working in or familiar with the construction sector might be aware of the Danny Sullivan or Balfour Beatty case. Nicky, can you talk us through that just so our audience can get a feel for a very real life scenario?
Sure. So I look at this from an employment law perspective, but it's, you know, the reason it's so significant, I think, to talk about it now are the potential tax ramifications of it, just as Ali has kind of talked through. Balfour Beatty carried out an audit of the organisations they used and the workers they had working on particular projects, and they discovered a problem. And the reason this arose was because a whistleblower working within the Danny Sullivan group who made reference to the fact that there may be being creative with the way in which they categorize their workers. You will hopefully know that there are various different categories of workers from an employment law perspective, but also from a tax perspective. So you have self-employed contractors who are responsible for their own tax. We could talk a little bit about PSCs, etc., but I'm really thinking about employment status here. They're not your employees, they're not your workers. You don't owe them any rights at all. You've got workers where you will deduct tax. They have limited employment law rights. They have the rights under the working time regs to certain hours of work and holiday, etc., but they don't have the rights to unfair dismissal or redundancy because they're workers. You then have employees. That's your top status, isn't it? That's the ones where you're making significant deductions and where you are absolutely owing them unfair dismissal rights, redundancy payments, etc., if you were to dismiss them after 2 years of employment. It's clearly beneficial to have someone working as a self-employed contractor from a tax perspective, and the whistleblowing was in relation to the categorization of the worker. When Balfour Beatty went through the process, their audit process, they identified that the Danny Sullivan group had incorrectly categorized the people that were working on the HS2 project, essentially. And so there was a big statement that was put out on the 4th of July by Balfour Beatty about terminating the arrangement with the Danny Sullivan group. I think that's a real wake-up call for lots of organisations to make sure they're really on top of the suppliers that they use, because you can ask for, and we talked about this, and Ali talked about this, you can do all the due diligence you like at the beginning of a relationship. You also need to keep on top of what's happening during the course of a relationship and use of an organisation. And I think it's quite tempting sometimes to kind of get through the due diligence, enter the commercial contract, not keep on top of it necessarily, but there was a real problem going on here. I think the issue about status from an employment law perspective is one of those ones that's hopefully on your radar. We've had the Uber cases, Pimlico Plumbers, etc. When I'm looking at status as an employment lawyer, I'm getting excited about things like mutuality of obligation, whether you have an unfettered right of substitution in order to determine whether someone's an employee, what rights they have, whether they're a worker, or whether they're actually truly a self-employed contractor. It's actually pretty hard to get to that, because when we think about unfettered rights of substitution, it's not all that common. You might remember the Deliveroo case, which are the people riding around, and it was found that they were subcontractors. Self-employed contractors, because they could replace each other. It's actually really unusual. Normally you are engaging with a self-employed contractor because you want their particular skill set. So you often won't be happy that they can substitute anybody for them. And that's completely understandable, but it does have an impact on employment rights. From a tax perspective, HMRC have a tool that often you will use to identify tax status, and hopefully your subcontractors are using to identify tax status. They're quite helpful sometimes to look at each other, but one doesn't determine the other. They are two separate principles, the tax status of an individual and the employment law status of an individual. Thinking about the kind of commercial aspects of this, I think it's the due diligence that you're carrying out at the beginning, but really thinking about the service level agreements that you have in place with your suppliers. So we're thinking about where liability sits from a tax perspective, but also the indemnities that you put in place. Ali talked about the fact that from April onwards, it's going to be no defence that you've carried out due diligence at all. So you start to think more commercially, I think, about liabilities and indemnities generally when you're entering your contracts. But yeah, it was an interesting one, and I think it's got lots of people thinking, basically, Jordanna.
Yeah, thanks, Nicky. And I just think, you think about the impact. If you mention HS2, Danny Sullivan, it's a huge reputational issue, not just for that supplier, that agency, but for the major infrastructure project that is HS2, just showing how quickly it can then ripple. The impact can be felt across the construction and rail sector. So thank you for bringing that to light for us.
And just quickly, Jordanna, of course, we saw yesterday in the budget as well that, the government is going to start tackling the CIS, the construction industry scheme as well. So, that's hugely expected, and start cancelling the gross status on some of those schemes where they believe tax evasion is set. So there's a huge focus on this whole market at the moment.
Yeah, I saw that explicitly called out, HMRC scrutiny over the construction sector. Okay, well, thank you so much, Nicky and Ali, as our experts. I'm going to now open up. We've got just over 10 minutes to open up to the floor. Final question before I do that for everybody. Thank you for your participation. It's the last one. How are you auditing risk across your agency supply chain? Across your agency supply chain, contractors and statement of work. So third party are managing that for me, audits are conducted internally, or no established mechanism. And if it's no idea at all, I suggest you go for item number 3. So let's have a little look where we are at the minute. Oh, bang on. Okay, third party and audits at the minute are 50-50. Got a couple of people saying no established mechanism. Third party is now leading the way. Yeah, okay. So how are you auditing risk across your supply chain, contractors and statement of work? Nearly 70% of people have said that's via third-party managed service. 31 have said internally, and just 8%, which I think is 1 or 2 people, have said there's no established mechanism. So it looks like a lot of that is via a third party. It goes without saying, obviously, just make sure that that third party is doing what they should and are aligned with these changes in legislation. Thank you, everybody, for your participation. We have had a couple of questions, so I will just read those out. Siobhan, thank you for a couple. So I'll start with your first one. How does joint and several, I imagine that's J&S, joint and several liability apply, if at all, in the following scenarios, and who is liable? So that first scenario is, I've contracted with a company who deliver their services most of the time using their employees, but often due to absence, they supplement their employees to deliver the service with agency workers. Ali, clearly not my question. Is that something that you're comfortable answering?
So just to make sure what we've got here, we've got a client here whose subcontractor services, and then the subcontractor engages with agency workers. Is that?
That's right. So the company delivers their services most of the time using employees, but often due to absence, they supplement those employees to deliver the service with agency workers. Siobhan, if you're comfortable just coming off the microphone, if you're able to, and just giving us any more context, that would be great. Context. It might be a technical logistics thing because
Okay. Well, I think I can answer this, because it depends how that subcontractor is engaging the agency workers. If those agency workers are engaged in an employment business, then the employment business will be liable. If the subcontractor is engaged directly with the umbrella company, then the subcontractor will be liable. because they're effectively the client in that case. So yeah, so in that scenario, it would be the employment business, or unless again you've got a connected person point in there. But yeah, it would be the employment business if they're sourcing the agency worker, or if the subcontractor is using a umbrella company directly, then it would be your subcontractor.
Thanks, Ali. And then the second scenario from Siobhan is, I've contracted with a company which the delivery of a service is outsourced, i.e. to cleaning or maintenance. Again, this could be delivered by a mix of either their employees or non-employees. So similar question, but where does joint and several liability fit in there?
Again, if there's an employment business sourcing those agency workers for your outsourced provider, it would sit with the employment business or neutral vend. Almost if you take those diagrams, which we can share, if you put yourself as a next step, I would, next to the client, I would put your role next to it, and then that would still show you the liability chain.
Okay. Thank you. We've got another question in the chat from Eva. How will the Employment Rights Bill impact umbrella companies? So we're talking about the ERB in terms of umbrella now. Given that umbrellas are the legal employer, will obligations such as guaranteed hours, etc., be passed on to the end client, who will ultimately hold liability?
So yeah, as an employer, the umbrella companies are obviously going to be subject to all the updated legislation under the ERB. The interesting thing I think we're talking about here is this tripart relationship where you've got an agency, guaranteed hours, end users, and the umbrella companies will be included, I think, in the definition of agency, basically. So you might be aware, and actually we talk about it on the last webinar a little bit, about the fact that agencies and end users are going to have a big discussion about this, basically, because it's going to be a split and it will really impact the relationship. And for use of umbrella companies, if ultimately end users are going to have to be offering the guaranteed hours contract, you start to think, okay, so what can we do about that? What use does the agency and the umbrella company have for us anymore? There's a bit about notification of shifts and where liability sits for cancelled shifts as well. And again, I think that will be up for debate between agencies, umbrella companies and end users in your SLAs that you have in place. So you're not excluded as an umbrella company. You're definitely going to have to pay attention to the ERB. The consultation on the agency and end user point has finished, but as with all things ERB related, we're still waiting for final details. It's really annoying, but I can't give you a firm answer because I need to see the detail of the regulations when they're drafted. And as I said, because we're in this ping pong and they haven't even agreed, the House of Lords and the House of Commons, about what should go in, we're still a little way off that. So it's that frustrating answer I have to give about all ERB issues, it seems. It's wait and see, but don't assume that you're off the hook as an umbrella company at all with this stuff.
And it's fair to say, isn't it, Nicky, that we haven't seen ping pong like this on legislation to this extent. And
there was a little bit that went through on the. Do you remember the strike action stuff where they tried to? Anyway, if you're not involved in strike action, don't need to worry about it too much. But that ping ponged a lot. But no, this is going on, and I'd expect it to be honest, because it's such a detailed piece of legislation.
Yeah.
So Nicky, we can do a 10-minute starter slot in our next 3 webinars with you saying it's ping pong still going.
Oh, I hope not. I hope I'm actually able to give you some decent answers, but yeah, maybe we'll wait and see.
You absolutely have. I think unless there are any more questions, please pop them in the chat. Paul, I think you had a couple of people reach out with questions before the session. I don't know whether you can quickly drop 1 or 2 of those into the chat because we've got a couple of minutes before we wrap up. That's Paul Lockett, obviously from Retinue. I'll just give you 30 seconds to pop those in if you can, but feel free if anybody else has got questions just to reach out. Paul's typing. Hopefully Paul's a quick typer.
I've just seen that Eva's asked a question about worker category, actually. Is it useful for me to talk about that one?
Yeah, please.
So worker and employee category is something that the government it will be consulting on. It's all wait and see, but they're looking to merge them. I don't think they think it's particularly helpful that we have this distinction. It remains at the moment, so keep going as you are. There will be another consultation about merging it. So eventually it will mean everybody having the same rights as employees, basically. So those unfair dismissal rights, because this government is very focused on employment protections. So they are looking to merge that. So you'd have self-employed and then worker/employee, whatever they determine the name should be. But that's definitely something to look out for.
Brilliant, thank you. Paul's just popped a question in that a client has asked us prior to this session. Can we use a candidate's pay slip to check that we are paying correctly? Presumably that's then paying workforce correctly.
Do you want me to take that one?
Thanks, Ali.
Yeah, it's a start, but unfortunately, you know, we audit our supply chain, we audit our umbrella companies, we have teams of people who check pay slips, and I know particularly in the Retinue world, I know some of your clients have that specifically built into their contracts, and even if they don't, I know that you perform some checks. I have seen a lot of forged pay slips. I have seen a lot of pay slips that don't match, and some of it's obvious, but unless you have the HMRC real-time information, it's really hard. If we go back to the DUCAS case, when employment businesses were looking at the pay slips, it looked like everything had been paid and it had all been deducted correctly. But what you don't know is what pay slip they're sending you matches the one that's being sent to the worker. I would always ask the worker for the pay slip, which is what we do. If we have a connection with the worker, we ask the worker for the pay slip, not the umbrella company. I would try and find the real-time information, because even if it's on the pay slip, doesn't mean they're paying it. We use, going back to SafeRec, it's one of the reasons why we've adopted that approach. They can run, you can upload a pay slip and then it will run against HMRC real-time information. So there's an API there, so it will run. So yes, you can, but please be aware. And you can't always tell, even like we have the most amazing payroll and billing team. We've got someone in our team who can pretty much look at a pay slip and go, that doesn't look right to me. But even they can't spot some of the fraudulent stuff that's come across our desks. And Retinue, I know you've got, because I help you with it, we suspend immediately. It's just it's a cold hard suspension while we investigate, and then termination straight off the supply chain. But so yes, you can, but you just have to be really aware that the pay slip alone isn't the full story.
Yeah, and I think that's a really valid point, because most people are on top of compliance, so checking right to work, checking DBS documents where it's relevant, but that pay slip can slip, sorry for the pun, under the radar. And like you said, Ali, we're talking to customers at the minute that don't take advantage of our pay slip audits and saying actually it gives you that second, third level down visibility that all contributes to reducing your risk as an overall. So again, if anybody wants some further information on that, feel free to reach out and we can quickly do a session with you.
And it's not just about, I mean, we're talking today about protecting and reducing risk in your supply chain and for all of you, but it's also a bit about the rights of your workers as well, because some of these schemes are not properly submitting national insurance contributions. That has a direct impact on the worker. Some of your workers will feel that they're better off under some of these schemes, and they are genuinely not. When we found just 3 historic DUCAS workers across our group of 25 plus employment businesses, very historic. We haven't used them, but these were historic and transferred. When we told them about the case and we reached out individually and told them about the case, they would not move. So we had to terminate their supply. But they felt that they would because they were they were seeing more in their take-home pay packet, they felt that they were better off. But really, that's not the case in the end.
Okay, thank you so much to everybody that's contributed. I think we will wrap up there. We're going to share contact information after this session, so anybody can ask any further questions, or like I said, take us up on that opportunity to do some assessment of your organisation from a monetary risk perspective, or we can just talk about how Retinue can support with your processes and protect you moving forward. Ali, Nicky, thank you so much for all of your guidance and expertise, and thank you to everybody for joining us. Have a great afternoon. Thanks, everyone.
Bye.
Bye. Thank you.